Hello there. Good morning. If you're joining us in the morning, it's morning here in South Austin, Texas on, what is it, October 25, 2018. Welcome to TEPSA Fast 15 Just-in-Time Learning. Today we're going to talk about reasonable force. What kind of reasonable force can an educator in Texas use on a student? We've learned through the ranks, and many veteran educators and a whole bunch of young educators believe the myth that you can't touch a student. And that's because we have been plagued with news and other cases and events about teachers and educators inappropriately touching students. This is not what this session's about. We know we cannot inappropriately touch a student. We cannot touch a student for a sexual reason or to solicit a romantic relationship, to groom a student for a personal confidant. Those are obviously off the table, will be dealt with in another presentation a later day. Today we're talking about what are the legal limits to you being able to touch a student in the course of your job. And look at the screen here, we have some examples. These are obvious things that come to mind, and we do these every day when we teach, especially in the elementary school realm. Look at the second bullet. Can a teacher hug an injured elementary child on the playground? The answer is yes. Okay, the answer is yes. Can you separate students who are fighting? Yes. Can a band director physically move marching band musicians around on the practice field? I was in marching band, that happened. Hey, trombone player, you need to move 3 steps to the left. You're on the wrong hash mark. Hey, trumpet player, move over here. Clarinet player. Happens all the time. Same with coaches, basketball, football. You're in the wrong spot. You need to move over here. Happens all the time for pedagogical reasons. Can you gently place your hand on the shoulder of a child to encourage him to sit back down or get back in line? The short answer to all of those is yes. The devil lies in the details, and that's what we're going to continue to look at here. Let's look at this one example here and see what we think of this. Dwayne "The Wreck" Johnson's the new assistant principal in No Trees ISD. He sees 2 students fighting like rabid cats in the hallway between classes. The Wreck attempts to separate the students, but he's having a hard time doing it because they're entangled. There's teeth, blood. It's a messy scene. He succeeds in separating the 2, and in doing so, hurls one of the students across the hall, crashing into the lockers. Now the parents want to take legal action against the Wreck. Let's assume they want to sue him. They want to file criminal charges against him. Geez, is the Wreck in legal trouble? We're going to come back and kind of try to address that and give it our best answer here in just a minute, but let's continue to set this up a little more. In Texas, you can be accused of assault 3 different ways, and only one requires that you actually cause bodily injury to someone, if you intentionally, knowingly, or recklessly cause bodily injury. But the other 2, the second one is intentionally or knowingly threatening somebody with bodily injury, just a threat, and the means to carry it out. And the third is intentionally or knowingly causing provocative physical contact, no bodily injury required. So it's the sum of this is it's pretty easy for someone to make a case for assault. You can lay it out pretty easily. Now I want to show you really the heart of this 15-minute Fast 15. This is the heart right here. If you just tuned in, you're in good shape. Now really start paying attention. Super duper pay attention. If you're watching this on your computer, take a big Sharpie and circle this slide. Obviously, don't use a Sharpie on your computer screen. But you know what I mean. This is the big slide. Texas Penal Code Section 9.62. Sounds a little arcane, sounds legalistic, sounds like I'm a lawyer trying to trick you with some fancy law. No, this is really an educator's best friend. This law's been on the books for decades, but it's been given new life in the recent decade. And it says educator student. That's what the law says. It's called educator student. And I'll paraphrase it for you, folks. It says that you as a certified educator can use reasonable force on a student to protect the student's safety, health, and welfare, the safety, health, and welfare of the campus community, and then furthermore, and most importantly, to further the special purpose or to maintain discipline in a group. To maintain discipline in a group. This does not mean, this has nothing to do with corporal punishment. I want to be really clear about that. It's to maintain discipline in a group. What are we talking about? If I could scroll back very quickly, look at this fourth bullet. Gently placing hand on shoulder of child to encourage him to sit down or get back in line. Maintaining discipline in a group with reasonable touching, reasonable force. This is what is allowed. Comes from the principle in loco parentis, I thought was Spanish for you as the educator act as the crazy parent between the bells, but that's not Spanish. I learned the hard way. It's Latin for in the place of the parent. In the place of the parent, between the bells, you are given a nominal bit of parental authority, namely the authority to gently, reasonably use force to maintain control of the educational environment and to protect the safety of the environment. So back to the wreck. Dwayne the Wreck Johnson. Is he going to be in legal trouble? I can't tell you. But I can tell you the courts or fact finders will look to these factors to see if the Dwayne the Wreck Johnson used reasonable force. They're going to compare the age, sex, physical, mental condition of the child. And I don't see it on here, but I know they're also going to look at the size and weight of the child, the size and weight of the teacher or educator, coach, principal, whatever. Obviously, if it's Dwayne the Wreck Johnson, and coming to mind is, you know, the big guy that I'm sort of referring to when I say Dwayne the Wreck Johnson, and is in a comical and satirical way. No offense, Rock, big fan. Big dude, though, separating little tiny people might be judged differently than a smaller educator separating big high school football players. The nature of the child's offense, the influence of this student upon the group, and then whether the force was reasonably necessary to compel obedience to proper command, whether it's disproportionate to the offense, unnecessarily degrading or likely to cause serious or permanent harm. So the hypothetical, let's just work this out. Does the wreck have a defense to the charge of assault? Certainly, a defense could be mounted for him. We don't have enough facts. We don't know how big or old these kids were. We do know, though, a salient fact was they were greatly injuring each other. There was blood, teeth, an entanglement of arms and legs. And I would say in a drastic situation like that, then it's all hands on deck. The wreck is jumping in there, acting on adrenaline and impulse. Doesn't have the luxury to say, boy, where is that Fast 15 webinar I saw with some lawyer telling me whether I can or can't break up this fight. No, he's going in and he's breaking up the fight, and he's trying to keep these students from hurting themselves more. I think we could probably defend Dwayne the Wreck Johnson in this very well. Devil's in the details. I just was talking to some assistant principals at a TEPSA conference this month and showed a video of a teacher breaking up a fight. And the girls, these middle school girls, were going at it pretty good. They were hurting each other. But then the teacher grabs one girl who was on top of the other one, grabs this girl on top by the backpack, and sort of turns her around and then throws her down the hall, kind of crashing into the lockers. A little bit like Dwayne the Wreck Johnson's scenario that we looked at. Devil's in the details. So who will think what of that? Will they give the teacher the benefit of the doubt for acting on impulse and breaking up a fight where adrenaline is surging? Are they going to say, well, this teacher was big and strong, picking up a middle school girl by her backpack, could have walked her down the hall, but he threw her? Devil's in the details. And these are going to be determined on a case-by-case basis. Did he have the duty to break up the fight? Important question. And the short answer in the interest of time today is no. An educator I have not found has a duty to dive in and risk life and limb in any kind of situation, but you do have a duty to not be deliberately indifferent. So you can't just stand around or ignore it when children are being hurt by each other or by a third party or by anybody that's in your purview. You need to do something, and that's pretty vague and loose, but you can't stand around. So run down the hall, get help. If you're unable to do that, get other people out of the way, press the panic button, call 911, whatever. I don't see that you have a duty to do that. Section 9.62, if you're using reasonable force, means you can't be fired by the school district. You can't be disciplined by TEA or SBEC. Now, who will determine whether this force is reasonable? In a termination case, independent hearing examiner. If a non-renewal case, the school board, maybe the commissioner on appeal. An aid or a para-dismissal, maybe the school board in a grievance. A certification action, we've got administrative judges looking at that. If it's a criminal or civil case, say the parents against the wreck, it's probably going to be a judge or a jury somewhere out in the hometown. So we can't be fired, we can't be punished by SBEC if we're using reasonable force, but if you violate the corporal punishment policies, meaning if the district doesn't have corporal punishment and you administer corporal punishment, I think that's big trouble for you. If the school does have corporal punishment policies and you violate them in the administration of it, that's a big problem for you. Basically, you have no legal immunity whatsoever for using corporal punishment, and we would strongly advise you not to do that. Can't use force on a kid merely because a child is unable or fails to perform, either academically or athletically, even if the teacher considers such force or violence to be instruction or encouragement. I think that there is sort of an unspoken rule that a lot of discipline goes on the football field, the basketball court, in PE. And I think this is thin ice. I'm not ruling it out. If someone wants to play this back, I'm not opining on how such a case would absolutely be determined, but it's not a stretch for someone to argue that if physical force or violence is used on a football field or in the gym for discipline, that it treads on being very dangerous for the child. I'm talking about the student, but really today I'm talking about the teacher. And what is your liability or ability to do this? What are the parameters? I would say if you're doing it for those reasons, be very careful. It must be pedagogically and reasonably rooted. Pedagogically rooted, not just for discipline and punishment. Practice pointers. You do these things, I think you're going to be in pretty good shape. If you will err on the side of protecting student safety, the law will likely follow you. Force may be used to protect the safety of the campus community. You can use self-defense. These are key here. Non-injurious, non-degrading, incidental contact may be used to protect classroom and campus order and to compel obedience to reasonable commands. Pedagogically legitimate force may be used. Think of the band director, basketball coach, moving people around. Here's the big problem, I think, is never use force in anger. The training example I referred to a minute ago where the teacher was able to lift the girl off and then throw her, I think is an example of anger taking the place of breaking up the fight and making sure students aren't injuring people anymore. We're now going to express our own anger at these kids and take it out on them. And I think that some pretty bright lines could be drawn there by people who wanted to argue against the educator, and we have to be very careful about that. Keep our adrenaline in check, and anytime something like that is happening, boy, try to get another grown-up or adult involved. 2 heads, 3 heads better than one. Finally, don't use corporal punishment. It's not worth it. You're not legally protected at all. Folks, we're out of our Fast 15 time, and I want to thank you for tuning in for another edition of TEPSA Fast 15 Just-in-Time Learning. See you next time.